Hello, how are we? Just to let you know, someone in North Carolina loves me. Thank you, Jersey Jen. Jersey Jen's here, so she gave me this. How are we, everybody? Hello, I can see some riffraff in the chat. Sarah P, Lady Di, uh, Jersey Jen's here. Rhonda's here. Hello, how are we all? If you're on Replay Crew or wherever, please make sure you like the stream and subscribe to the channel if you haven't done so. And yeah, hit the notification bell on the way in. If you'd like to support the channel, here's a few links and they're attached to the top as well. These are some of our social media groups. And yeah, you can also become a member, which we will hopefully be shortly doing some member only content. So we're back. There was a lot of confusion today about when court started. It was yesterday I heard it was 1:30 today, then it was 9 o'clock, then back to 1:30. So yeah, it's been back and forward, but here we are. We are here. We're back, and it's good to see everybody. Hello, Tuts. How are you? Hope you're doing well as well. They will be starting in about 12 minutes. So it's one of those things. It's a difficult. I honestly don't know what's going to happen. They're talking about the Brady and also Morton Act. They said, and I found out today actually that the Morton Act is an act in Texas to ensure that everyone passes everything over fully, because there was an incident by a guy called, I think it was Edward Morton, and he was incarcerated for 20 plus years for, allegedly, wrongfully, that he killed his wife, and DNA years afterwards, after 20 plus years, exonerated him. And he was exonerated because the prosecution didn't pass everything over. So very similar to Brady. And the judge that exonerated Edward Morton is the judge we have here today. So he's the same judge that exonerated that defendant. So that guy, he spent 20 plus years in prison for a crime he did not commit. And the judge that exonerated him under that new law is this judge. And I only found that out literally about 10 minutes ago, about that this was the judge involved. So I did not know that until 10 minutes ago. So yeah, that's very interesting. So I think what they were saying was that the prosecution was trying to say stuff yesterday that wasn't true. And they were like, well, this judge knows everything about this act because he was the one involved in it. So yeah, there's a lot of debate whether they are going to ask for a mistrial or not. I think most people believe that they will not get a mistrial with prejudice. If you get a mistrial with prejudice, it means that he can never be tried again. And they do not believe that will happen. Well, a lot of people, commenters, don't believe that will happen. But they do believe mistrial might happen. So it's up to then the defense. Do they actually want the mistrial or not? To come back in a couple of months and redo this? Or will they find some common ground or something? We don't know. We'll see how it plays out on this. It'll be very interesting, I think. Very, very interesting. Hello, Andriel. Hillis. Andriel, how are you, my darling? Hope you're doing well. I highly doubt that will happen in Texas. They absolutely retry. Yeah, I mean, I don't think the judge will grant with prejudice. But wait, I don't know. We don't know. I don't know. It's gonna be, yeah, it's gonna be interesting. I will say. Right, we got a couple of commenters on here from this. Right, let me. The court is open. Hang on. I'll put it on the screen. Um, hang on, I need to change viewings here. So you'll see. Um, Yes, if it's just a mistrial, Sarah, they'll 100% retry it. It's just more if the judge allows it mistrial with prejudice. Hang on, here we
I
go.
see a little bit of movement in here. People are standing
Judge
up.
is
That means the
coming in.
judge
coming
has
in.
entered
Right, here we go.
the room is when they start standing up like that. But the hearing's not slated to start until 1:30.
Oh, defense.
The
not there.
jury is not here today, and of course the reason for that is this special hearing.
Yes, so just a reminder, the jury's not here. They're back 9 o'clock tomorrow morning, and so is the first witness. They're back first thing tomorrow. I'm not sure where the defense is. But the defendant and the defense are the ones. The judge is on. Okay. Let's have a look, see what they're saying.
I guarantee the very first thing the defense is going to want to do, and frankly, probably the judge and everybody's going to want to do, is ask those jurors. They'll probably ask them one by one, did you watch any media coverage? Did anyone mention to you what's going on? Because, as you said, these are human beings. It's going to be extremely hard not to Google it. They've all got to be so curious as to what in the world just happened. And
Yeah, why did we get sent home?
Right.
What's happening?
And so, it would be very normal human behavior against the rules, but very normal human behavior for them to go look into it. And if they did, that in and of itself could cause a mistrial.
Right.
And so, it is a thorny situation. Ultimately, the judge has a lot of power in this. He can declare a mistrial. He can say that was a violation of Brady and Michael Morton, and I find that impacts the ability to have a fair trial, and therefore, or he can, under a change in the law that happened just last year, they now can exclude evidence for an untimely Michael Morton disclosure. So if the judge finds you should have disclosed it, you didn't, it came out way too late, but I'm not going to declare a mistrial, he could say, I'm going to exclude that evidence. And so in this case, that would be the testimony of that witness, of the teacher we already heard. The problem with that is, of course, as Rebecca said, that bell's been rung.
Yeah, how do you unring it?
You don't. I mean, you don't. And
they still heard it.
Exactly. They heard it. And I think the defense would argue very aggressively against that because understandably, how do you unhear something you already heard? But we do have that mechanism in law. It's a little bit of a farce, but the judge said...
just sharing stuff for social media. Hello, Dirk. It has been a long time. Hope you're doing well, Dirk Digler.
All the stuff about the prosecutor being put under oath and all that happens outside their presence.
They don't know this wasn't disclosed. They don't know that there's anything wrong with that. They just know they heard her say one thing, then the defense said, wait a minute, you never said that before. So that's got to be interesting. And then all of a sudden, all this rush out the courtroom, hush, hush. So, but, the other issue with that is the defense would be able to argue, look, Judge, this was extremely compelling testimony. Prior to this all coming out that she had never said this before, you and I were commenting about how her...
In fairness, we're 6 minutes early, so in fairness, I thought we were about to start, but it doesn't seem like we are about to start. But yeah, I this could be anticlimactic, obviously. But it could also bring fireworks. I think the judge knows what he's going to do, probably. They're all going to have to bring case law and stuff like that in front of him, but I think he knows most judges know linear of what they're going to do and stuff, so... we're talking Marilyn Monroe today again, are we? JFK, Marilyn Monroe. Sure. Love it. So you see Jersey Jen, you bring in Marilyn Monroe and Lazy Die goes off for one. Okay, that's fine. But we'll be back early tomorrow. Oh, he's got his phone out. Normal time, 9 o'clock. We'll probably be back at 8:45 Central, 9:45 Eastern tomorrow, because they'll be on Central Time and they start at 9 o'clock. And this judge looks like he likes to be prompt, so... He's already out there waiting. I suppose this is just a hearing, so it doesn't really matter that he's there. He just probably is like, well, let's get on with it, you know. Because normally they wait until everyone's in and then the judge comes out, but what else have I got to say?
Favor of mistrial. I think it's going to come down to I would assume we're going to hear more testimony, more evidence about what was heard, what was said. You know, the problem they have though is just in the little part we reheard earlier from when the female prosecutor was testifying under oath, she couldn't say affirmatively, definitively, the teacher did not tell us that. She says, I'm in and out of the room. Nothing like that struck me as oh my gosh, that's a big deal. So she doesn't remember. And so, you know, she can't say.
That's always convenient. If you just say, I don't remember. So you're not lying in the sense of, you're not saying it didn't happen, but very convenient. These prosecutors like to do that. I don't remember doing it. So if somebody says, no, it did actually happen. Oh, yeah. Okay. Hello, Murph. Yes. I hope today is as spicy as yesterday. I know. I hope so as well. But I'm also hoping it's not, ladies, when you go on a date and you're going to get lucky that night, and then you do get lucky and it ends up being like, oh, is that it? That was short and quick. That's disappointing. I hope it's not one of those. Do you know what I mean? I hope it's not one of those. Okay, the judge has left the bench and the defense still aren't there. So that's interesting. They might be running late. I don't really, but why would they run late? I don't know what's happening.
And you know, I've had other prosecutors where they won't talk to a witness without another prosecutor and or a district attorney's office investigator in the room, and they're taking notes. Right. That way, you know, I can engage in questions and Tanya can be the one taking notes. Right. But, you know.
And that creates a better system of justice, because the idea of justice is not, because the old way used to be just about winning and getting convictions, and that didn't necessarily lead to justice.
No,
it led to a lot of wrongful convictions. We saw that with issues with eyewitness testimony. We saw that with lineups.
I'm sure you've had plenty of those nights, Lady Di. Plenty of them.
Beginning to change the way that they did lineups. They would do the double, what's called double blind, where the person that is actually doing the lineup for the witness doesn't know who the suspect is. Because what was happening in the old days is the detective would basically, you'd have, 6 pictures, and you'd have one picture that looked substantially different than the others, and then the detective would be like, wink, wink, nod, nod. And so you would end up with these horrific wrongful convictions. DNA in some cases would later prove that the person didn't do it. Then you would and then you had other cases with eyewitness testimony where, because of the lack of disclosure, all these things would happen. And that's the reason behind these changes in the law.
Well, going back to the original Michael Morton case, it was witness testimony that was withheld. In Michael Morton's case, Michael Morton's son told his grandmother, so the victim of the murder, told the victim's mother that dad wasn't home, and the mother.
Hope you're doing well, Sherry. I think you were with your mother-in-law yesterday, so I hope she's doing well as well. That is Bex's song, the cunt song. How's that P, Lady Di? There you go. Hey, Lefty, how we doing? Sup, nerds? Hope you're doing well. Hello, lovely. Hope you're doing well, my darling. Well, to be fair, they did arrive on time, so they were here on time. Yeah, you got a song. I haven't played your song.
Guess what? You're a bitch.
Doing great. I got lucky with happy days. Happy days. Good. I'm glad. I know what, everyone seems to be sick. Sarah P was being sick for days as well. Everyone seems to be sick at the minute. Not good. I've not been 100%, but I'm a little bit better now. Hope you get better soon. You're a joy. That's not what your husband says. You're a grumpy cunt. There you go. Josie Murph, yes. You all know what's happening. You all know what's going to happen. And they're both here. If normally it's just one of them, but today you got both here.
Josie, I'm Murph Turf.
Be what it is.
It would just be what it is, and it looks like our hearing is just about to start. Everybody just rose.
Find out. I'm joking. They're lovely.
They just judge just came on.
Because I think with the filing system and this our defense strategy is what you asked for. I would just ask,
It'll be
have to
sealed.
file it, but you ask that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflect that I'm tendering to the court my notes, all of my notes. Tendering to the court my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced. And I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this, under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but, if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and And frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building. And she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, sir. In addition, just so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
yeah, I'm going to deny the motion for mistrial over your objection, obviously, and I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, sir. It is not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses as aged in anticipation of their motions. I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Yeah.
The first copy is for the judge. I'm sorry.
okay, thank you.
I just want to file stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written?
They
Did you file something?
No, no.
Okay, okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
So, I don't know, Your Honor, can we confer as to possible remedies? And see if we can come up with a solution? Would the court be open to that?
I mean, if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, if you want to just go back to my office, I'll stay here and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes, the state joins you.
So I believe that the defense don't want it thrown out because they want to play her full testimony. So currently, I don't believe the defense want it to be thrown out because they've heard it. So that's what I'm led to believe. But we'll see now. Hey, Vixie, how are you, my darling? Nice to see you. Hope you're doing well. Let's listen to what they're going to say.
Put on more witnesses. We had thought that the state might call more witnesses to say, oh, and so was also in that meeting, and now they're going to say what they did or didn't hear, and that we might actually have kind of a full-blown hearing. It sounds like there probably wasn't other witnesses that were in existence, and both sides then made what are called in camera. So in camera means that they take directly to the judge something, a filing, whatever. The general rule is neither side can talk to the judge directly without the other side there. And the idea for that is, justice, you don't want one side.
It's called ex parte.
Exactly. There you go, ex parte. So, you don't want the judge, somebody whispering in the judge's ear and the other side didn't get to say, wait a minute, that's actually not true. So that's the general rule. However, there are times where you allow for an ex parte, a direct to the judge. So you say, Judge, here are documents that I don't want the other side to see. What the defense disclosed was an entire briefing on here's what our defense strategy is, and here's how this affects our defense strategy. Well, obviously, it wouldn't make any sense to require that to be seen by the prosecution. Because,
Right.
So you allow for that direct. So both sides made direct submissions to him in camera. They each had kind of put together their filings, and he had already read a lot of that before he even came in. And right off the bat, look, I'm not going to grant a mistrial. So before we started this, I said there were two options. There's a mistrial, and there's he could exclude the evidence under. And I didn't say Heath, but Heath is the big case that changed the law in 2024. And I guess we could talk more about that.
Yeah, walk people through Heath, what that case was, what it did, and it's a fresh ruling.
It's 2024, and it was a big deal. It is a big deal. It was a big change. So prior to Heath, the law in Texas was to exclude evidence. You had to have a showing of bad faith. You had to show that the prosecutor back there was, I know what I'm doing.
It's malicious.
It's malicious. It's intentional. So when you heard the judge say, I make a finding that it's not intentional, that at best, and then he said, actually, at worst, it was negligent.
Yeah.
What he's saying here is, look, I don't find, and I think this is what my feeling was too, is I didn't see anything that made it really clear that this is a, he's not the guy.
It didn't feel like a gotcha to me.
Yeah. It wasn't huge. It was important, and it's definitely important to the defense's entire strategy, but it wasn't such an obvious thing that it had to be intentional. And so prior to Heath, you could not exclude evidence unless it was intentional. And so what Heath said was a couple of things. One, it doesn't have to be intentional. The judge has discretion. They're not required to exclude evidence just because there's an unintentional violation, but they can. And two, in the Heath case, the state was arguing, because in that case, the prosecution hadn't gotten evidence turned over to them from the police, the police department. So the police officer hadn't turned over certain evidence, and the prosecutor then obviously didn't turn it over to the defense. And the prosecution in Heath argued, we can't be held responsible for what the police don't give us. And of course, the court said, no. It doesn't say the DA's office. It says the state. And the state is not just, a euphemism for a prosecutor. It is the prosecutor's office and all of the agents within the police department, the sheriff's department, et cetera, et cetera. So Heath was two big changes. It's everybody. It doesn't matter if you don't have the evidence. If somebody in your control has the evidence, then you're responsible for it. But the big one is that you don't have to find a showing of bad faith.
Right. And so, but it gives the judge kind of a remedy here.
Exactly. Because the problem was, prior to Heath, you either had to go mistrial or nothing. You can't exclude the testimony. You don't have that power. And so, the defense could sit there and say, you got to be kidding me. So they can just violate the law left and right, and there's nothing we can do, as long as the judge isn't willing to grant a mistrial. So Heath, I think a lot of prosecutors' offices really hate Heath, but I think Heath is a really common sense remedy. It is, look, it doesn't require the judge to do it, but if the judge thinks it needs to be done, the judge has discretion to do that, to exclude evidence. So in the Heath case, it was, I think, a 911 call that had never been disclosed. In this instance, it's going to be the testimony of the witness. Although, and this is what we were talking about beforehand, what's thorny about this is not just a 911 call that the state doesn't get to put in because they didn't turn it over. This is a witness who's already testified. So how do you exclude that? Well, you tell the jury to not think about the elephant in the room, to forget the things they heard, and so that's why now we're all talking about, can we craft a remedy? The judge was talking about, he had already kind of thought what the defense was thinking of, allowing them the ability to put in the prior statement she made to the ranger. So it's going to be interesting to see how this turns out.
Yeah, I don't know exactly what the judge. I mean, obviously he's not going to grant a mistrial, but sort of how the remedy gets crafted, I think, is what we're waiting to see. Seems like.
So I believe that they don't want it to be dismissed outright because they want her testimony, her interview with the ranger to be in. And the reason they want the interview to be in is because she doesn't mention anything about seeing the shooter. So that was her original statement. She never saw the shooter. Now, 4 years later, she's saying she did see the shooter in passing. But then they will probably argue that, well, I'm just foreseeing they will argue that her memory was better 4 years ago after the incident than what it is 4 years later, where she's not told anybody about seeing the gunman. So that would be the reason they want to play it. And possibly what they were saying then is they want to play that and then for the judge to dismiss the testimony. So that balances out what she had said and then what she actually told the officers or wherever it was straight afterwards, if that makes sense. So that balances out in their minds. That's better than nothing. So yeah, I think it'd probably be the fairest way, and especially I was surprised they said that they would want to play and then dismiss it, but I get it as well because then they play it. At least that is something in the jury's mind then, and then they can dismiss her testimony after that. Yeah, it's all very weird. But then Texas is very weird. So everything's bigger and better in Texas, they say. So I don't know. So it'd be interesting to see what they're going to do. But I think pretty much everybody knew that he wasn't going to do mistrial. I actually don't think they wanted a mistrial either. So because it would have been really hard for them to regain themselves for the next trial. Because in the next trial, they wouldn't be able to dismiss her testimony. She would testify that she saw the shooter. At least now, there will be some sort of remedy in place, which is more to the advantage of the defendant. Whereas a mistrial, you might think is a win for the next couple of months, but then they're going to retry it, and then she's going to come back in and just say, yes, she saw the gunman, and that plays up with the strategy of the defense, which I think, their strategy at the minute is that, so if we remember from yesterday, I'm not sure if I do I have this? Bear with me. See, I should have it somewhere here. Image file. Images. Lady die. Hippie chicks nudes. Yeah. Right. Okay. So if you remember down here, so they're saying, well, hang on. Let me open it up a bit better because you can't see it that way. I'll open it up and I can zoom in then. So remove, if I do this, remove from studio. Image, no, that's not what I want. Hang on, here we go, I got it. I'll just go through my nudes, you hippie chick. Right, so what they're saying in a minute is that he is here. She placed him, the gunman, around this area. But what this defense is saying is that the gunman was around here and we're in here. So they will be saying that these three officers up the top here. Oh, hang on. I can write it. Hang on. Let me move this for a second. Oh, no, I can't write that. Shit. I can't put this up here. Well, they're saying at the minute. Yeah, so these three, which are, in my opinion, where the friggin' hell is it gone now? Oh, I'm having a mare here. I'm having an absolute mare. Why am I having a mare for? Right, here. Right, I got it back. So, yes. The cursor, he's here. She placed him, the gunman, around these parts here. He's obviously there. So at the minute, they say, well, he's not really in a line of sight. These three officers up here would have seen him go in, or should have seen him go in to this door here. So they will say that those three up here are more culpable than their client, the defendant here. But by placing the shooter around here, that's in the line of sight a lot clearer, which is the problem for the defense. They can't go with that argument that he couldn't have seen the gunman. Whereas if he was here, he would have seen the gunman more than likely. So that's why this testimony is very important. And that's why obviously I have the remedy of her not saying in the first interview that she saw the gunman is a remedy that I think the defense are happy with. So, and then they will exclude the testimony, I imagine. Also opens a question, should these three not be more culpable than him because they have line of sight? So there's some big questions here about how it all comes down, but that's going to be, it's a huge argument for them. This is not like a small thing in the case. This is a huge part of their case. Because if you can place the gunman here, their strategy falls apart a little bit. I was talking to Merv's Turf this morning about this. The fact that, they're saying, oh, he should have seen the gunman be between cars when he zoomed in. Do you remember he zoomed in here and then parked up here? Well, the testimony was that he thought there was somebody on the floor, and that might be someone injured or somebody, maybe even the gunman themselves. So he's concentrated so much on that. That's why he didn't see the gunman here. So when the defense said at the start that this is all timing and it's all fine lines and stuff, that's what they meant. Basically, this is really, really tight about what happened, how did it happen, why did it happen. So every little intricacy is important. Every time, every second is important for them. So, right. I hope that makes sense. If it doesn't, oh well. Don't say something about memory and a Dever came to mind, but I know that's not a situation at all. Here, my apologies. Don't apologize. You're all good. Never apologize. You're fine. I don't know why you didn't have to apologize. You never have to apologize, Jersey Jen. Right. So Lovely does not like this ruling. It's irremediable, in my opinion. He doesn't seem to think so. And I think if you hold the defense to the fire, I think if they get to play that tape, I think they would be happy with that. I don't think he will offer a mistrial with prejudice, which means they're going to retry him. And I think that's worse for the defendant than better. Because in a new trial, they'll be able to bring all this information in. Where now, it should get excluded. So that's the difference. So I think this is something the defense will be very happy about. They won't publicly say they're happy, but I think they will be happy. Oh, hang on. They're back. I think they're back. Oh, shit. Hang on. I've lost something. Let me pause it for a second. Right. Hang on. Stop that. Bring this on. Share screen.
You're welcome to verify the clerk is sealing those documents.
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, but them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
yeah,
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion in limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children are, the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? Can I make sure?
Yeah, and I guess yes, I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right. You see what I mean? And so, what it does is it puts us in a situation where that remedy could actually harm our client worse. All right.
Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we resting, or actually she's finished with redirect and
Okay.
recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement.
The prosecutor, I'll tell you why now. The prosecutor is a
You're a cunt. You're a cunt.
You are a cunt. You're a cunt.
You're a cunt. You're a cunt. You're a cunt. You're a cunt.
The reason he's a cunt is because the judge just said that he was willing to strike the testimony. So just to be clear, the compromise they came to in the jury room was that they would allow the defense to, this is between the prosecutor and the defense. The defense will question, cross the witness. They will play the tape of her original statement, and then there'll be a redirect. And then after that, the defense will have the option to exclude the whole testimony. The judge said, that's fine, but just to put it on record, I'm willing to scrap it all now. The reason then you see the prosecutor go back, because they want to scrap it now. The prosecution want it scrapped right now, because that means then the defense can't play the tape. So they agreed to a remedy. This is what I hate about prosecutors. They came together, they agreed on something because it's, on balance, it's quite fair to both parties. They got to unring the bell, play the whole recording, sort of, compromises it, no problems. And actually, I do actually think it's a win for the defense. As soon as the judge says, oh, well, I was going to scrap it, straight away, fuck that deal. This one's better for us. So I don't care about justice for your client. This is better for us. So now they don't want to compromise. Thankfully, the judge saw through that and is like, yeah, no, we're going to let them do what they want to do. And if they then want to scrap the whole testimony, they can. And the defense definitely want that, because they can then, as I said earlier on, they can bang on to the jury in closings that, look, whatever they want to do, but essentially saying this was her first testament. She never saw the shooter in the line of sight. But what an absolute cunt that prosecutor was. As soon as he went back, I knew what he was doing as well. Your crown has never been threatened. But that's such a dick move to do. The prosecutors, they are there for justice, no matter what. They're there for justice, and they're supposed to be there for justice, ensure a fair trial, and make sure that the right person gets prosecuted and all that. But as soon as they see something thinking, oh, this will benefit us to get the guy convicted, that in real time, we just saw a prosecutor go from agreeing to something, shaking hands on something, to then saying, fuck you, we don't want that anymore, because I think the other one will benefit us. So, yeah. So, yeah. Right, hang on. Katie says, I agree with this, by the way. Yes, I agree. My count is one of the harshest in the state. They are concerned with the win. It's very, very unfortunate. Lovely says, I understand. I can agree to 80% of what you're saying, Dylan. It's all wild and saying that this is even happening right during the trial. Hopefully this will all work out for the best. Now, just to reiterate, though, if I thought that there's going to be mistrial with prejudice, though, Lovely, I agree. It should be that. But I think the defense knew that was never going to happen. The best case scenario is always a mistrial. And I don't think that benefits the defendant. If there's a mistrial with prejudice, which means they could not retry it, absolutely. Let's go. Let's freaking go. We should be going for that. But that wasn't on the table. It was going to be just a mistrial, which then would lead to a new trial, which I do think would be a disadvantage to the defendant. That's the reason why I lean towards it. Okay, let's listen a little bit more to this.
And then that's when this issue came up, and so I would just continue with the cross-examination.
They passed her and she's on cross?
Yes, Your Honor.
Okay, all right, very good. All right, so 9:00 tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
I agree with you, Lovely. It should be for truth and justice. Do you know what? I totally agree with you, but unfortunately, I think we see in so many trials, a lot of you who've been here a long time will know that there's so many trials that we've watched that they like not just prosecutors, but I've seen like a lot of shady attorneys and judges out there, and it's now I don't like it. I don't like it. I go back to the Kitsap trial in Seattle when the prosecutors were allowed to submit evidence about those what do you call them? Those radios, and the defense were able to prove. So they say two-way radios were used to kill the family, as in to coordinate. So they were allowed to put that in as evidence to say these were used in the killing, and the defense were able to prove that they weren't, because they weren't even created until like 2 years after the murders. But the judge still allowed it in, and the prosecutors didn't give a shit. They still submitted it. They knew it wasn't, but they told the jury they were used for the murders. Like, that is just like appalling. You know, that's just one example. I see Joe's in the chat. You think back about Zachariah Anderson. You know, in the open statements, the prosecutor was like, "Oh my God, you can see so much blood." You know, he cleaned the van clean. He bleached it all out. He bought bleach. He did this. And when you see the van's dirty. There's a hole in the carpet in the van, which they said was full of blood, and that's why, you know, he took it out. But then they got witnesses to say, no, that the hole in the carpet's been there for a fair bit before the murder occurred. But they just fit it into a narrative, and that's what's scary. These people, they, you know, you'd like to think that they plead to an oath. And I don't want to tar everybody with the same brush and say everybody is unethical, because many people aren't. They're very, very good and very ethical. But there are some attorneys out there just for the win. They lose sight of it, and it's about numbers and about like success and about, I need to win this. So I don't care how I win it, I just need to win it. And they're willing to convict anybody. They just want successful cases on their record, not actual truth. That's very true. And also, it's scary to think that, you know, when it comes to cold cases, a lot of departments and prosecutors they are under pressure to try cases to get them off. So there will be some prosecutors who will never admit it, but it will be true that there will be cold cases there that they're encouraged to try them. And it doesn't matter if they win it or lose it. It doesn't matter. It's just off the shelf. They could just take it off the shelf. I can guarantee you there's prosecutors that have taken stuff to trial knowing it's going to lose or should lose, but it gets them off the shelf, so they don't care. And that's not a very good way to work. I understand there's a lot of pressure of people about cold cases, but you shouldn't arrest people and prosecute people just to get paperwork off your desk. You know, this is people's lives, but until you or a close family member or friend lives through it, you just don't get it. You just don't understand, and that's horrendous. And it goes back to this trial. You know, again, I have all the sympathy in the world for the victims and their families. You know, this is horrible. I just don't understand why. I genuinely feel right now that if you go into an angle of this guy was culpable and the others weren't, then I call bullshit, because there were 3 officers outside that, in my mind, were more culpable if you want to go down that route. But to me, you know, the most culpable person here, and I think we've lost sight of this, I think the prosecutors and maybe to a certain extent the families have lost sight. the person responsible for this is the actual killer. You know, I'm not saying that there's no sanctions that should be in place, but if you're gonna prosecute one, then you should prosecute all 400 of them, or however many there were involved in all this. I just don't agree with highlighting just one person, or in this case, two people. That's not how it should be done, because I always worry about what impact does this have on resource officers in the future. Do they even rush to the scene anymore? I know they will also always say, "Oh yeah, I'll be first one there," but when you see these kind of cases that you can end up in prison, it's scary to think, well, fuck, you know, or even do they make the right decisions? Because in the back of their heads, in the back of their brains, they're thinking, shit, am I going to be like up in court if I don't do X, Y, and Z? And that's why I think it's dangerous ground to hold these kind of trials and only have one person accountable for it. I believe that the person accountable for this was a shooter. That shooter's dead. So that shooter, that was the justice. He's dead. Obviously, that's not enough for people. Fine, but there's other ways to do this. This doesn't. This feels dirty to me. What we're doing right now, it just feels dirty. I think it's got a bigger impact than what they think, because I generally, if I was a school resource officer, I'd be worried. You know, you'd say the right things, that you would always run in and do whatever, but even if you think you're doing the right thing, you know, in 2 years' time, they might review and go, well, actually, you delayed yourself by 10 seconds. So in that 10 seconds, you could have saved something or saved someone. So actually, we're going to now take you to court. I just think it's a very dangerous precedent. Now, obviously, I'm not making a sweeping statement to say that everything falls in that category. I do think there are people that are culpable and stuff like that, but in this case alone, I don't believe we should be here, you know. So just my tuppence worth. Talking about cheating bastards. Here she is.
Hippie chick, lady di, spacey Stacy, walking those streets all night. You go, ladies, come and see what's going on now. Let's go, girls.
That's what I mean. How do you choose? And I know I've said this yesterday as well. How do you just choose this guy? You know, again, I'm just looking at this, what we've known already. Why this guy, not the three guys that were right by the entry point? Why? Do you know what I mean? He was on site first. Who cares? They were closer to the incident than he was. It just doesn't make any sense. I will be closing it in a second, yes, because we've got a long day tomorrow. We'll be back tomorrow. It'll be like an 8-hour day again tomorrow, so I'm trying to take advantage. Also, I need to be up early tomorrow. I'm going shopping tomorrow, so with the snow, we've had snow. It's actually cleared today, so tomorrow I can go to the store, go shopping, maybe go Starbucks, have a coffee, because on Friday or Thursday night. Friday, there's more snow coming, so yeah, we need to go and buy some stuff. Right, so all three of the cheaters are here: Hippie Chick, Spacey Stacy, and Lady Di are here. Good. I like to keep tabs on them. Just because this guy was on the scene first, he was trying to figure out where the shots were coming from. You don't run in blind. That's also true. But also, the question I wanted to ask as well is, when you're in a moment like that and you're panicking and stuff, yeah, you say training kicks in, but like, he's not SWAT or anything. You can go on any course in the world, but it's not exactly like proper training. I mean, I could be trained to do ballerina. Doesn't mean I'd be any fucking good at it. If I was had to do, like, I can do some ballerina moves, I could spin around and stuff, but that doesn't mean I could do a concert. Oh, fuck, here she is. Beware, people. Beware. Where's it gone?
Erin Hartree drives a bus, yellow bus, yellow bus. Erin Hartree drives a bus all day long.
I know. Well, you know, you be fine. You be fine. So you did miss some parts of it, actually. Again, I just think it's awful. The judge, the prosecutors wanted to get with the defense to come up with a conclusion, and they came up with a conclusion of what to do. The judge said not mistrial. I didn't feel it was that level. So what they came to conclusion was that the defense will play the recorded video of her first interview, where she doesn't mention anything about seeing any gunman, and then there'll be a redirect, and then the defense, if they wish to, can exclude her testimony as a whole, which I think is very fair. They'll have that option. The judge then said, well, that's fine. I was going to give you the option anyway to basically get rid of her testimony. As soon as he said that, the prosecutor went back to the table and he came back and said, actually, yeah, we just prefer if you exclude the whole testimony, because they don't want the jury to hear her first recording, which is shady. So you shake on a deal and then you renegade on a deal. That's a piece of shit right there. I don't like stuff like that. That's shadiness 101. She's going to St. Martin. Oh, no. Enjoy yourself. You're always on holiday, you are now. Enjoy yourself, my darling. Hope it goes well. Erin la ha ka ka. Ole. Vixie, nice to see Vixie as well. Right. Yeah, I hope you're still doing well. I hope Mrs. Hack is doing well. I hope Mrs. Hack, well, at least she's got Hack Jr. looking after her. Hey Dave, Blue Collar Dave, how are you? Hope you're doing well, my friend. Mexi, hello, you're late. I'm not explaining it again. But no, do you know what I mean though? I'm fed up of the shadiness of it all. I just don't like the shadiness of it, like, you know. But yeah, anyway, that's how I feel. I'd be interested to see. She's back on tomorrow. She was to start at 9 o'clock Central, so we will go live around 8:45 Central, 9:45 Eastern, which is, I believe, 9:49. That's 2:45 UK time tomorrow. I've already set the stream up ready, so the surgery juice makes me mum act funny. Some days I think that you're on some funny juice, Aaron Hack. Buenos dias. Is that goodbye? I thought that was goodbye. But anyway, there's not much more for me, Dad. I am going shopping tomorrow. I need to buy some vegetables. I'm going to get a Starbucks and get prepped for tomorrow, you know. So, but before I do go, please make sure that you like the stream. If you haven't done so, please subscribe to the channel. And yeah, I need to have an early bed tonight, early sleep tonight. So I will be back because tomorrow's going to be like an 8-hour stream. So it's going to be a long one. Do you know what I mean? Maybe even 9 hours again for this judge. I think he likes to go all night long. So when I get the opportunity, so your boyfriend didn't speak. He didn't speak at all. You see a glimpse of him, but he didn't really get involved. Bye-bye. So yeah. Right, everybody. I do love you, most of you, not all of you, just most of you. And but yeah, I'm going to take advantage of this early night and finish it there and spend 8-9 hours with you tomorrow. So the joys of streaming trials, and then it's Thursday, then Friday as well. Yes. All night long. I laugh because of this. Yeah, mostly. Thank you very much, lovely. You're always lovely to me. Thank you, my darling. Right, everyone. I'm going to go back on Twitter to see what's going on with college football and everything because it's fucking crazy out there with what's going on. So enjoy your holiday, Spacey Stacey. Enjoy the streets. Yeah, be careful out there, whatever you do. Right, everyone. Take care of yourselves. Good night. Good night. Bye-bye.